G'day everyone, it's Alan Endres here, founder of ZuCoins and ZuCas. Today's the 28th of September. This is episode 11, which is all about asset protection. And welcome to It's ZuTime again. Today, little program is about firstly giving you an update and just on the wallets. We've got another 20 wallets going out, which will be tested all this week with those people. So when you get them, good luck. The most important thing to remember about the wallet that we're finding, everybody, is just get used to the fact that when you receive the SMS and you download and you install the wallet, that you follow those instructions, particularly for the iPhone, because the iPhone means that you need to scroll down, and you'll see this when you get the wallet, to be able to add in the icon onto your home page, which allows you then to press and open the wallet. Now, I'll just touch on this again. This is an important bit because, as you recall from earlier episodes, the whole decentralization and the system that we are using is built around progressive web apps, PWA. These are, in fact, links to a web page rather than creating a full app that is caught and trapped in iPhone stores or Google stores. So they are not like the normal iPhones that apps that you see. These are PWAs, and for good reason. And we're going to drum this home because the good reason is that it is decentralized. It can't be controlled by the giants. When you get the links from other participants in the network, you will be able to transfer and make sure that the movement of your fractions or coins are received by anybody with a phone in the world through the SMS. And of course, that means there's a little process there that you need to visualize the icon. Now, we're at about a 75% success rate on the last lot of wallets, and it still just means a bit of an education process. And we've got Robert and the team having a look at maybe some ways that we can automate that little bit of that function instead of getting people's heads around scrolling down. It's not hard. The reality is it's not hard. You've just got to follow the instructions and read what's in front of you. Funnily enough, the bracket of education is those under 40. So look, just follow that, and then we can all get more excited as we continue with the soft launch of getting that to 100% strike rate on those wallets, which allows us to then release all the wallets. So again, just patience with your fellow ZuCoin buyers, everybody. Don't go jumping up and down and carrying on about it. The reality is it's an education that's working its way through, and we still are working on some visuals in relation to the tutorials to get that ready when the full-blown amount of wallets go out. So don't expect any great excitement this week because we'll get the handle on how that 20 wallets go for the remainder of this week, probably early into next week. But that's the reality we're up to on the update side. Now, today's not going to be a long one. I just wanted to give an overview, moving on from episode 10 about easy bonds. I'm hoping everybody took some time to get through that because that has a significant bearing on our mass adoption and the way in which we process. Won't go over that again. I will say that where I'm heading with all of this, of course, circles around the long-term value prospects that we see, of which our entire business model is built on the quantity theory of money. And as a basis of that, that gives us that formula MV equals PT that we are using. So that all comes down to product lines. I had some questions come through yesterday from the Easy Bond Follow update. And the significance of that is that we are, ZuCas is just, as I said, one business that is able to be in a position to bring to the coin holders and those in that decentralized world 4 lines of product. And there will be more, but certainly we're focused on virtual real estate, which is an incredible opportunity using the coins and that value of the coins. The second being the lotteries, which is going to be massive. The third, obviously, that we're focused on is ZuCas vouchers. And then we want to make sure we build out the UDAs, which is our version of an NFT, but with far better technology We call them unique digital assets. And they are unique because they're going to be unique on the split chain protocol, which means that you are in possession of your UDA, unlike the NFTs, which are already starting to see some cracks in terms of people not understanding that you actually don't have possession. It's simply a case that the referral link, if you like, to a pointer, that code is built into the blockchain, and that points you in the direction of somebody that's storing that visual, that picture, etc. So on that basis, you can see that the overall big picture is that we're in the middle of this start of the soft launch has been continuing, in the middle of it, getting excited for the releases there, of course, to everybody. But more importantly, once you are in possession of your coin and wallet, you're on your own, and there needs to be some thought about how this process is going to come into play. So on that basis, everybody, let's talk about the way in which I look at asset protection. Now, there's good reason for it, because in another episode, I'll be talking in depth to those that want to be interested in relation to the court proceedings that I've had over my journey. And, it has been a difficult journey because the road that we had was, as just a recap, received $8.725 million in relation to monies from the government. And as a consequence of that, that's when the journey started, both the government throwing everything at us, and me in particular, freezing of assets, losing up to $200 million worth of exceptional mining leases, and all of those sort of things that had occurred that even led to the government, by the way, trying to throw the suggestion that either myself or others and Peter Kane had knowledge of David Muir in relation to a conspiracy to defraud, which was what the criminal charges were. Now, the interesting thing of that was that aside from our assets being frozen and assets destroyed, the government just wanted to really put the nail in and suggest that we're involved in some criminal conspiracy. The good news was, ladies and gentlemen, if people take the time to research properly, you'll see that we were acquitted of all of those criminal associations with Muir, that we had no knowledge whatsoever. It was all completely debunked, and God bless him, Chief Justice Higgins in the Supreme Court of the ACT, it didn't even go to jury. That's how pathetic the government's case was in trying to associate us with David Muir. It turned out it was all the actions of David as a government contractor, as their man. It was the government's own responsibility that had caused that to happen. The government had failings and in its systems, and as a result of those failings, where they had passwords that were shared and access to the Reserve Bank, that this was allowed to have occurred. And in fact, there's an April 1999 report from Ernst & Young that's very scathing, that I've put up on the Davis Samuel social media channels, finally being able to release, that talks about that. Now, why am I talking about that? Because when these things happen that you don't see coming, it can be devastating. And it can be devastating not just because, on one hand, you lose the assets because you didn't think through where you're heading into the future, or what may come out of left field, but more importantly, when you get caught up in some of these cases, you don't have access to any reserves to fight these cases because you're innocent. There's absolute lot of rubbish that goes on when someone accuses you of something and you're not on the same playing field in the court system, which means you need access to some sort of reserves of capital. Now, for me, fortunately, I had some amazing business associates and friends that supported us from my days with Easy Bonds and in both Australia and overseas. And then the other advantage was that both Peter and I, coming from a corporate litigation background, we were able to do some of our research and also put up the ability for us to be in court to defend ourselves. Now, you don't want to defend yourselves. It's a scary prospect, but you do want some asset backing to as a rainy day to be tucked away. Now, this rainy day situation, in my case, was a court environment, because then, of course, ASIC gets involved and runs around and tries to discredit you and throw up all this stuff. But And there's a lot of material on this. And, next thing they want to ban you as a director. And in that instance, they had the ASIC proceedings against us, which was a tactic, very good tactic, by the way. One of those great tactics that I'm sure Sun Tzu in Art of War would have used, and they used it against us, is to try and stop your revenue. That is, your ability to earn any money to fund anything. So that's the next step in their little program they roll out. Now, the funny twist to the ASIC case was, yes, we're going to ban Mr. Endres because he had 2 transactions and with Mr. Forge that was payments made from the company through to their private businesses, which is right. There's no doubt about that. The irony is I'm the only director in Australian corporate history banned on transactions that were 97.3% approved, ratified by the very shareholders, the 1,393 shareholders, which has never happened in corporate history. So there's a lot more to come on that, and that's why every dog has his day, and I'm a very patient man, and there's more to come through my High Court actions that will reverse the ASIC proceedings, because there's a lot of litigation that's involved in that will come out about that it was not able to be put in play in the first place. And secondly, obviously, the 4.3 billion claim that I talk about, which is backed up and verifiable through evaluations and those prospects. No question of that, no doubt about that the government will be paying a hefty price and a big lump sum check. Now, again, I'm going to come back to the asset protection. A smaller part of that asset protection problem was that not thinking about where you're going in life, or you're not here to deliberately deceive or fraudulently do anything. You're just bubbling along, and someone comes along and has an accusation that's quite outrageous, absurd, has no legal foundation. And the other tactic the government did was to freeze the private property that my wife and I owned. And it never occurred to us through all the legal advices that we should have more protection mechanisms on your private property, asset protection. Now, just as an update on that front, and how devastating that can be, the original amount that was traced into the house, the property, is about $310,000. Now, that's what the claim of the government, the total claim was recovery of 8.725, which is fine. And that, in fact, has been paid in full. Now, more recently, for 22 years, I've been fighting to hold on to the private property, which is worth a lot of money. And that was all, built up from assets and monies and projects we'd made prior to even knowing what the government does with its world. But nevertheless, losing that particular in the first instance meant that, and because the case took so long, that you're subject to another left field problem if you do go down this road. Not just court costs, but under the Supreme Court rules in the ACT in particular, there's a mismatch of the interest that the great politicians decide that in court proceedings one should receive beyond a reflection of the current market. And if in fact that average interest rate, annualized interest rates, around about 7-8%. Now, you can compare that with the current market in terms of loans today. I mean, the young ones get wound up if they're paying 3%. But because the judge, Justice Revshurgi, the great man, he takes 6 years to hand down a decision, which then went against us, I've been subject to 6 years of interest compounding as a result of the total of the $8 million, which affected the amount that compounded on the house. Now, you don't see that coming when you're wet behind the ears and you're having a great time in your life. And again, you don't put asset protection planning in place. Now, I'm using the house as an example because it's a very personal item. Now, for $300,000, that debt has grown to just over 1.8 million, which is all interest that accumulates effectively as a result of the judge not being able to make a decision for 6 years. Now, this particular judge, Rashurgi, there's no love lost between us, is a gentleman that prides himself, or thought he did, about how he tackled the understanding of the law. But for most part of the case, he was falling asleep during the trial. Now, I put up an application on the basis that this gentleman was not in a position to understand what was happening in the course of the trial, because he's nodding off at about 2 o'clock every afternoon, which is 42 days in the process. So I made an application. Now, that's a recorded court judgment of trying to remove the judge on the basis that he was incompetent in relation to even just being attuned to the proceedings. Now, of course, the irony of that is available for everyone to read and see, and that decision was that I was mistaken, because he indicated that when I looked up at the bench, his eyes may have been at a 90-degree angle pointing towards the top of his desk, but he did have a pen in his hand and he wasn't making any squiggles, which meant that he was awake the whole time and just listening. Now, I mean, you can do a Monty Python comedy on that, and there's a lot of funny things we're going to talk about this judge and things in the future. But again, the decision that was made was decisions made that affected our personal lives and the house and the property. Now, most recently, we've had to come to consent orders with the government that have effectively, through the trusts operation, that we've had to buy the property back again for just over 2.85 million, of which that goes to the government, which annoys the hell out of me, because I'm waiting on wanting to attack the counterclaims against the Commonwealth. So the Commonwealth and the bankruptcy trustee are going to pick up a lazy 2.85 million, and we've had to buy the house back again after 22 years. Why? Because the judge, A, went asleep during the trial, and B, couldn't make a decision for 6 years. Now, unfortunately, that's the court system. And to be honest, the reason for the property is because that is the home of which my wife has built her wonderful gardens and her landscapes, and the money that we had hard earned prior to 1999 through our business activities, and we were going very nicely, thank you very much, in those days. And certainly she has terminal cancer. She is not in a position to enjoy life the way that we all see it, with not long to live. And the decision was made that that's where she wants to die. So, there's compelling reasons, obviously, for that. But we wouldn't have been through that stress factor if we'd have had the knowledge that we have today, which I'm sharing with you about the way you can go about in a very cheap cost exercise of asset protection. So, ladies and gentlemen, let's talk about that and what we've learned from our corporate perspective. Now, I'm not going to go into the high-level documentation that I would want people to see and to put to their own advisors, but I'm going to break it in two parts. One is for the ZuTime buyers that have tipped in some money, they've put their risks in, they understand that they may lose it all, or they may make an absolute poultice of money. And we are here, my team, what we've built up, which is the basis upon which I've strategically put out these episodes, so that you're getting a bigger picture of my thinking and what I know to share with you, is that whether you've got $100 or whether you've got $1 million in ZuCoins, it's valuable, important to each and every person. It's crucial that you protect whatever that is, because people forget that when things start out small, and then others who have FOMO, they're the ones that'll bag you out, because you got in early and you've taken the risks and you've picked onto some technology, and that's the exciting part in any investment segment, that something may happen that'll take you from $100, $200, and you look at Bitcoin in 2009, and people laugh when they were 10 cents, 10 cents, 15 cents, 20 cents. The great story of the guy that gave up a truckload of Bitcoin for a pizza. Now, it was a good thing at the time because they didn't have any value. But, you're talking hundreds of millions of dollars from that. We know what people have done with early adopters in companies, great companies like Google. $10,000 has turned into $1 billion. You've got Facebook. You've got a whole range of those sort of entities. And even, you look at poor old Ethereum. The value propositions are huge. But I can tell you now that the thinking in the human mind about latching onto something and then putting in your head that this is going to be worth a lot and putting an asset protection in place before it actually happens, it very rarely happens. I mean, even the greats in the corporate world, the great titans in the world, failed to put in place protection mechanisms before they've made the money, before they've made any wealth. And unfortunately, that's exactly the category that Peter Kane and I found ourselves in through Davis Samuel. We had some of the best mining leases in New South Wales, which is subject to the damages. 5,000 square kilometres of the Lachlan Fold Belt, where there's been two major discoveries on the very tenements that we owned worth hundreds of millions of dollars. So they were our tenements, and we lost them because we didn't plan for it. Because even as Peter Kane is a practicing solicitor, and Peter and I being enjoying my corporate world and accounting, we just didn't think. It never occurred to us that you need to put it in place before the very day you start making some money. So for those that aren't in a business as such, which can, I'll talk about that in a minute, because there's different techniques for the businesses that we promote. And not here to shake the can for money. I'm not interested in that. I couldn't give a stuff. The fact is, I want to share this with people, and we're going to send out some links with the trust deeds and the documents, and you can take them and you can look at them and you can send them to others and you can share them, and you can cause some grief to those people out there that are the doubters and to those that may attack you in the future of your precious assets. But for the individual, the little guy in the street that's picked up some coins and may very well turn, those coins from, I'm telling you, $600 could revert to $600,000. This is my advice. Now, there's a little thing called a trust declaration. Okay, now it's a 2-page document. We've had this document, which I'll be sharing to everybody. And it's a very simple document. And the world gets caught up in, all of this corporate stuff that's been around for 1,000 years, that you've got to have companies and entities and all the rest of it, because it tends to be driven by the control issues of the regulators who are putting in place onerous laws, and also the tax office. I mean, if anybody's taken the time to look at the tax book in 1936 to where we are today, it's one of the most complicated pieces of legislation in global history, in all jurisdictions, because they're grappling at things just to grab hold of your money and looking for ways and means to either A, get it, and B, stop you from doing things that may or may not be legal at the time. But certainly, the money grab is the big problem, and it could be simplified. The whole structure of government and the way in which they collect money could be simplified. Now, if you think about, the way in which I just got a little question coming through. We've got one of our guys that what they do is, these guys, it's interesting, and you may see it through what we're putting out on Telegram. They post a lot of negative stuff, but in fact, they're big supporters of us, and they quite love to test the type of negative commentary, or they make things up in relation to some of the material without actually reviewing it themselves. And that's great, because it gives me the opportunity to say, well, as we expand globally, you want to make sure that you can sort of collate that negative commentary, and then make sure that you've got the answers and you can respond accordingly with the positive outcomes. So we're pleased that they're helping us in that regard. It's been very valuable in an instance. So young Sam's come on board. That's not his name, of course, but he's talking about the remittances with AUSTRAC and compliance, and can't find me on the register. Well, the reason that we're not on the 2021 registers, because we're not processing transactions, Sam. The entity is Easy Bonds Pacific LP. It's been registered as a designated remittance provider since 2006, and we filed our last report, which is in 2020. And of course, what happens there is that if we ever going back into remittance in Australia, then of course that means that we would need to re-invoke that remittance designation with AUSTRAC, and we advise them accordingly. So there is a legal process. Now, I understand that you're not attuned to any of the legal issues in the world and what that means, but that's why in the Easy Bonds update, it clearly was the basis upon which we were able to get the exemption from global remittance through the processes in the United States when you're processing from C to B, that is consumer to business, and you're completely exempt. So no, appreciate that, Sam. Great comment. And yes, these guys, they've got these little these sites that they run around, and they have phony sites and all the rest of it, which is enjoyable. Although having said that, there's sometimes some naughty things that are posted that will get them in trouble, which we're building a profile on that in terms of how that operates and the way in which we'll find out. So that's that point. But coming back to the trust declarations, everybody, on the assets, there is no legal impediment that you as an individual, if you have a trust that's set up, where what we're saying is that you always have your trust set up that you are an individual as the trustee of the trust. Now, the reason for that is that accountants and lawyers tend to focus on having a corporate trustee, that is, it might be ABC Proprietary Limited, acting as trustee of, let's in this instance talk about a family trust, a discretionary family trust. Now, I'm talking in Australian law, but globally, the trust concepts have been carried through for centuries from the great British Empire and before, and that's transitioned into very solid principles of trust law through most of the Western world, and countries that were within the Commonwealth under the UK. So from an Australian perspective, what you have is accountants and advisors saying, I'd like to set up some protection and also minimise the tax according to the company tax rates. So we'll set you up with ABC Proprietary Limited as trustee of the ABC Family Trust. Now, the ABC Family Trust allows the beneficiaries to be nominated, of which the primary purpose from an accounting point of view is the distribution of profits made in that trust to either A, individuals, or B, nominated entities to take the tax hit. So the thinking on trusts is all about tax. Worried about the tax. So, we've got to have these structures. Now, the downside with a company is twofold, really. The first point is that whether you're a private company or public company, you are at the behest of the Corporations Law, Corporations Act. So you are subject to the same laws and regulations in relation to the way in which that's handled by, obviously, the overseer of that being ASIC, Australian Securities Investment Commission. And they're quite onerous. I mean, the guy in the street that ends up as a mum and dad director, where they own 100% of their own company. It's only acting as trustee. It's effectively dormant. It's not trading in its own right, and it's acting as trustee of the family trust to conduct business or put assets in. You still have the same onerous problems as though you were sitting on the board of a public company, because the big one, of course, is that you're bubbling along and you're starting to trade and you're trading insolvent, which puts you into a difficult position because you've got to know when to pull the pin prior to continuing to trade insolvent. Otherwise, there's prospects of going to jail. Now, the other issue is that you think you're trading through the trust and you may not make any money, but certainly the trust has got some assets and you take out a loan. Now, you might withdraw for food $500 for the week, and that creates a loan account. That means you owe that back to the trust. Now, because you've got a corporate trustee, the tax office starts to get excited and says, well, there's a Division 7 issue there, and therefore that means that loan can actually be fully taxable. Now, the answer to that is they say, we'll put a proper loan contract in place between the individual and the entity, the trust, in order to overcome that net commercial rates. So either A, you pay interest on the $500 to your very own entity, which is then taxable, or B, you don't enter in a commercial arrangement and the whole $500 is taxable. Now, this has been devastating for a lot of farming communities, because the farming communities don't necessarily, unless they're having good times, make a lot of losses. And of course, they need to survive. So they borrow from a bank, the trusts. The bank obviously has the bank accounts there, which they draw money to pay for their daily living and expenses, and they build up massive loan accounts, which can be fully taxable under this concept of having a corporate trustee. So the way through that is that the second point about the corporate trustee is that if that trustee goes down, then as directors, even though it's your private entity, you have all sorts of duties and responsibilities of the way in which that company conducts its business as trustee. Now, it could very well be in relation to that company that you also have other director breaches as a result of that company going into liquidation and recovery. There's no corporate veil or shield in this current world today of any advantage of so-called protection as a director because you're in a company. Absolutely zip. The courts will tear it to shreds and work its way through to create that liability to the directors. So the days of 100 years ago, which is what the whole concept of the company was, the idea was to put a protection mechanism around those that manage the operations of the company, to put shareholders to one side, that they've got rights and they're entitled to whatever the productivity of that entity does in terms of dividends and growth in the value of their shares, and put a shield around directors that says, well, if something happens, the company is liable and you can't attack the assets of the director. Well, that's gone. It doesn't work. It's the biggest load of garbage we've ever seen. So the structure of a company is simply driven by minimizing the tax rate down as low as possible to the company corporate rates, rather than paying 48, 50 cents in the dollar as an individual. Now, even there, the company you can have that low rate and you can pay the company tax. And then they have this wonderful concept called franking credits that says, well, at the end of the day, you still want to get it out of the company because you want the money. You either pay the dividends, which then can be at the highest individual rates with an offset with the franking credit, but you're still going to pay the tax anyway over and above the difference. And you can't just take the money out of the entity because then you're caught up with all this Division 7 stuff. So what does that all mean? It means that you revert back to maximizing your protection as an individual person. You as the person can be the trustee of a very simple family trust. Okay? Now, that puts you as trustee of the trust. That allows you, with all the power and the provisions in the trustee, to conduct the business as you see fit. It means that there is no corporate exposure whatsoever. It means that any claims against you as the trustee certainly are in a position where people can still claim their money, but it's through the equity courts. It's not through, if there's a creditor there and you're struggling in your business as a company, guess what? You get a demand notice and they can wind you up in 21 days. Well, they won't be doing that as if you're an individual and you've got some creditor situation. Now, that creditor, you're not there to deceive the creditors. You're conducting either your individual business and you're trying to make it work. And then COVID comes along, government gives you a handout, which, let me say this, we've got a couple of million payroll on our staff and we didn't want to take a cent from the government for obvious reasons, for JobKeeper and all the rest of it. It's not worth the Trojan horse coming into the room and look at the consequences of what's happened with that. Companies that legitimately took money copped a powering bagging out, number of companies, because they retained the money and didn't want to pay it back. Well, it wasn't a matter about paying it back. It was just that the government botched up in not making the terms and conditions clear as to whether it was repayable or not. So those are the issues with the company structures. But as an individual with a trustee, you're in a position to at least control your destiny and put the assets in that trust. Now, one of the things in a trust deed, which has really come to light in a recent High Court case, and that case, ladies and gentlemen, is called Carter Holt Harvey Wood Products, Australia, versus the Commonwealth, 2019, HCA 20. I'll put this in an email to you because it's for those that are interested and want to read it. It was the really test of the way in which the High Court treated the relationship between the trustee and the trust deed, or the trust itself, with what's called a right of indemnity. Now, a right of indemnity means that if I'm the trustee and liability has been incurred from me, I have the right to claim that against the assets of the trust. Now, that's an interesting one. It's been around for a long time. Now, it's not statutory mandated or anything. And many years ago, and probably the better part of 10 now, Peter Kane and I analysed the consequences of what does the right of indemnity mean if you're the trustee. And we found that it's a disaster. It's an old concept of protecting independent trustees that are not in your family environment, in order to claim back monies if something went wrong, that they got sued as the trustee and claim it against the assets of the trust. Now, that works okay, but not okay if they're your very own assets. You don't want to be suing your own trust. Now, the High Court case said, in this instance, it was a company in liquidation, that for the purposes of insolvency and in terms of bankruptcy, and I'm a great expert in bankruptcy, by the way, everybody. As you know, this is my fourth one now to work my way through into the High Court. Having succeeded against the government 3 times in the past, but very comfortable with asset protection and very comfortable chasing down the government for what we rightfully believe will be ours and our shareholders, 1,393 people. The reality is that under the Bankruptcy Act, similar to the insolvency provisions of the company, Section 116 says that the moment you're bankrupt, all of your assets reside with the trustee in bankruptcy. Now, that includes other property. Property is very broad. And what the High Court decision basically means is that that property can include your right of indemnity against your own trust. So there's a hole there, that because of the right of indemnity that was put in trust deeds, that your bankruptcy trustee can still attack the assets that you thought were protected in the trust through that right of indemnity. Now, Peter and I had removed that concept of right indemnity 10 years ago. There's no need for it, especially if you want asset protection. So we've taken that out of the deeds many, many years ago, and lo and behold, in 2019, this case comes down and it's affirmed what we believed many years ago would be the consequence if that happens in the bankruptcy trustee or insolvency for that matter. So the trust deeds that we've created, one is a family trust deed. 2 is the what we call a hybrid trust deed. Now, the hybrid's a bit more complicated, but for the purposes of those coin holders, the deed that we send out for everybody to look at simply is the family trust deed is the first thing you need to put in place. That is, you, as trustee of the family trust, manages your affairs through that trust. Everything you do, whether you buy the house, you won't get caught up in the house saga that we've had, because the trust would own the property. Now, you may have borrowings from banks and things, but the trust borrows that and you pay accordingly based on those assets. But cars, for example, why do you need to have ownership of your vehicle in your name? It's absolute nonsense. Put it in the trust. There's no tax effect in relation to that, because you're not going to be claiming deductions as a business expense. It's a private asset protection trust vehicle. That is the family trust. So things that you want to buy, things that you want to do, doesn't matter. The list goes on and on. In our case, I'm quite open about it, which was in a recent case that I've been very excited about and expecting some big outcomes through Alligator Blood, my horse, through my syndicate. I don't own anything. I don't own any horses. The assets are held by the trust, which gives the ability that even as a bankrupt, because it's not property that's mine, because it's owned by the trusts, you can actually continue to manage those assets as trustee, even as a bankrupt. Now, people have trouble getting their head on that, but that's the reality of the way in which the structures work. And that material came out in the recent case where we have been proceeding to sue Racing Queensland and Racing Australia in relation to the lack of natural justice principles of which the horse was disqualified in a race. And we're feeling confident about that, very confident. The tone of the court and the lack of or the admission that there's no natural justice principles, the rights that we didn't have in relation to that, could very well be that that would be successful. Now, that would lead to the declaration we're seeing that the disqualification was null and void and illegal, and therefore reinstall the horse to the win and the prize money. Now, again, in this example, that prize money resides back with the trust, and it's tax-free because it's in the racing industry. It's not a business. So that's a classic example in relation to putting something in a very simple family trust with you as trustee. Very important that the individual acts as the trustee. Forget about worrying about the tax element and the corporate element when the advice has come through that says you need a corporate trustee. That is where the beginnings of the problem start. And if you do make a truckload of money in the trust and you do distribute it to the individuals, well, pay the tax. Pay the tax. If it means that you've made money, that's a good thing. Get your accountant's head on making money instead of trying to avoid paying tax and worrying about all the deductions. If you've got money in the bank and you've got an asset and it's protected and it's shielded, then good luck to you, because that puts you in a better position that says if something comes out of nowhere, then you can protect yourself and you've got access to capital to fight the claims from people that are wishing to take you on for whatever reason it may be. And you won't be in the position where your house that you worked your ass off gets caught up in some nonsense of the case of third parties, where the government blames, in my case, that because we received some money, that we're the ones to blame in relation to that transaction. Well, the blame lays fairly at the foot of the government, because they didn't have software systems in place. That effectively $300 million is missing because they don't have the controls and systems. And that's not me saying that. That's Ernst & Young in April of 1999. So the trustee that you'll see will send out as the family trust with a view on a flow chart as to how what I've described works. Now, if that's too complicated, because that's more looking towards the business community, there's a step back, which is this 2-page declaration of trust that I've indicated before. And all it says is, my name's Alan Endres, and I declare that I'm holding this asset. It could be a bank account. It could be ownership in a horse. It could be anything your mind can imagine as an asset. It could be a pen. You don't want to own the pen, or you don't want to own the desk or the filing cabinet behind me. And you declare quite properly that asset is held on behalf of someone else. And in this instance, it could be your family trust. So as assets have been accumulated, your file is getting thicker with the declarations of trust. That you don't own a thing. It's not yours. Legally and binding, you are declaring that this is not your asset. And that's what you would do with your coins. Set your structure up at the beginning. Now, in Australian law, a trust deed, sure, you've got to get it stamped through stamp duty. And that and you have a copy of that as well. And basically that's about 500 Aussie dollars. Now, the good news is, because you are an individual as trustee of that trust, and $500 is your investment for protection for the future, of which your coins would be in that trust. You can open a bank account with it. You can do all of your business through it. The banks readily accept, as long as the deeds are stamped. Then, of course, you're in a position to open your accounts. They know that you're the beneficial, the trustee. The deed says there's no right of indemnity. Certainly, at that point, with that opening of that account, you can readily move on with the accumulation and a register of those assets through the financial statements that are produced in relation to that trust. Now, the wonderful thing from that's just the beginning of where I see the protection mechanisms. And do not go through the journeys that I've had, because we were silly enough not to put this in place at the beginning, and stupid enough to be in a position where we've paid our house out 10 times more than what we would have had in the first instance had we had some protections in place. Now, there is a complicated structuring that we've used around the world, which adds another layer of protection beyond the family trust. Now, this is really only just touching on briefly for those that are in business that really want to look at some serious asset protection in that business environment. And that's called the hybrid trust. Now, the hybrid trust is a discretionary trust, but it has fixed units in the trust, a bit like shares with different classes. And those classes of units create different entitlements based on what your business model would be pursuant to that trust. Now, you may have simply A, B, C, D, E classes of units, and the A class may be entitled to all of the capital and the rights and income, still at the discretion of the trustee. And they're a more valuable unit because they are more closer to your heart in terms of what that trust is building up as assets. But you do have other classes that you can categorize. And one might be that, you've got a friend that comes in and you've decided to get into business and he's going to stump up some capital, but you don't want him running the business. So the class of unit may be that he ends up with a D class, and that D class gives no voting rights. It just means that there's a discretion in terms of he may only be entitled to 30% of the profits or capital, or a combination of both. And that's the class of unit that fits within this hybrid trust. Now, if you combine the firepower of the family trust, one I've just described for personal use, and all of a sudden you add that to the hybrid trust, well, then, of course, that hybrid trust interconnects, and that puts a shield around the assets of both the hybrid as well as the family trust. And we've got a strategic flow of how that works, and that means that it allows businesses to grow. And if your business starts out with one cafe and you're in that structure and you end up with a chain of cafes, then that structure accommodates that growth, and that structure accommodates the protection and the assets within those structures. It turns out to be very common sense without all of the exposures and risks that may occur. So we will share those materials. As I said, please yourself. I'm a leading example and case example of what can happen through no fault of our own in terms of things that come out of nowhere. And in any corporate environment and any part of it that you see, certainly these things can happen in a day-to-day life that you don't see coming. Now we've got some time. I'll get the team to send out an EDM with some of that material, a bit more explained. I'm just putting it there to all the ZuTime buyers that if you're in expectations of making a lot of money, which I am in a position that I expect personally to make a lot of money through that. I've seen it happen with Easy Bonds value propositions, which is in episode 10. We know what our strategies, and we'll talk more about our marketing in further episodes as to how that's going to be achieved. Then put the protection in place and enjoy the journey and enjoy the assets, and give yourself an even chance with fighting anything that comes out from nowhere in your life's journey, because it will. As I said in an earlier episode, there's one thing that we all have in common, and that is we all get to die, and the rest of it's just a road towards that outcome. How you end up from there is a matter for your own beliefs. And I know that I hold myself in good stead. I know morally where I sit, and those pearly gates is something that gives me something to look forward to. So a couple of questions have come through. Tony Sanderson. Now, Tony, he's one of these guys that we have on board with our project, that we make sure that they follow through with their negative commentaries and enjoy. And I do share it because it's worth, it's a bit of like exciting banter, because you want to take these young fellas on and see what they've got, because they don't have much. They're wet behind the ears. They try their best. They try and use the social media to some sort of advantage. But at the end of the day, they've just got this big FOMO, and for whatever reason, they tend to miss the boat, and that's a sad part of their lives. But look, Tony's come in. Tony's not his real name, by the way, and he wants to know about my mental state. Well, Tony, that's a very tough question, but certainly, if you're a doctor or a psychologist, I'd invite you, a therapist, then maybe the expertise that you have you can take this particular recording and get an analysis done and send me a report, because if it's concerning you, then certainly in order for me to help you with your mental state, I would have thought that it's an opportunity that that'll help you through your current predicament and your mental condition to work out what my mental condition is. Because I know it's a bit overwhelming, Tony, and it's a difficult concepts to comprehend the breadth and extent of what my journey's been through accounting and litigation, etc. And there's no issues about blaming anybody else. Look, the reality is, if something has happened to you and you are confident with your position and you have a belief in yourself, then there's no point resonating that you hold yourself accountable, Tony. It's just a question that something has happened, and it's not about blame. It's just about a matter of pointing it at the direction of how did this occur, and do you take responsibility if you were part of that? Well, I was not a part of anything to do with the government action other than receiving the monies through government project. Just like people have received funds today, there's a lot of people that have received monies because the government wants to keep the economy going. $60 billion went out the door, and nobody's whinging about the mental state of receiving that money, or even testing has the government legally appropriated those funds to fund your weekly lifestyle out of Section 83 of the Constitution. Was it properly appropriated or constitutionally valid? So you don't question that, Tony. And certainly when the government has massive deficiencies in their systems, which they still have today, and they still have projects in Australia at least that are unaccountable. For example, the Manus Island contracts, Tony, would those people that received $80 million before a contract was signed, in fact, took 6 months, would they be blaming themselves for receiving government money because of the stupidity of government? I don't think so. There was no contracts in place, no documentation, but the government was on its merry way to solve a particular problem at the time. Or do you consider, for example, the $4 billion spent on pink bats, where there was 3 deaths and the ministers, walked away? Do you think those families of those boys that died would be sitting there worrying about commentary that says, you blame everybody else? Of course, you pinpoint the people responsible and you take them to task. That's the reality. So any other questions coming through? Let me just see what we've got here. Yeah, look, we've got Robert Boys. He's pretty keen on understanding a little bit, which I'll digress. It's worth talking about. Robert Boys, it's another name that doesn't resonate as a real name. So again, we're dealing with the anonymous world. These people like to hide and but throw it out. But it's a good question because it's something that came up in the courts. And the question is that our family's dire financial situation at the time, quick with the management fees. Well, to understand the transaction at the time when we had the money come through, our company, our private entities in the main company, which was CTC Resources at the time, certainly we put all the monies, our private funds, into that business, and no one had been paid for 9 years, either my parents or myself, or through directors' fees, or any of those normal channels that you would get paid, because we ploughed the money back in. And bearing in mind it's an unlisted public company, 1,393 shareholders, we then went to shareholders in relation to paying $2,205,000 over that 9-year period, which works out about $90,000 annually and a couple $100,000 annually for me. And that was the total that was paid retrospectively in back pay, which was approved by shareholders. So prior to that, of course, David Samuel, I think our set of accounts in 98 showed net profits of about 2.7 million. We had retainer contracts of about $500,000 a month based on our legal advices with a number of public companies. And again, we had in train, for example, a company called Tresman A, which also had in addition to the I alluded to earlier, it had another 3,000 square kilometres of mining leases worth tens of millions, and very comfortable. So look, Robert Boys, Robert Anonymous Boys, little boys, whatever. I'm very, very happy to take the questions. There's an answer to it. You don't obviously read, but more importantly, there's a power of information that covers off on those issues, which we stand by. No issues at all. And certainly that's part of the claim, because what you forget is that because of the actions of the government, that I haven't been, not that I want to, but I haven't been in a position of earning funds as a director. You can multiply that out on an annualized basis based on our latest set of accounts in last set of accounts in 1998. That I do have a personal claim, which is about 6.9 million against the government, in addition to the 4.3 billion, which compounds with interest on the same rates of the Supreme Court that the government's just claimed in relation to our house. And effectively, you multiply that out by a factor of about 15, and I'm looking forward to some massive compensation in that 22-year journey. That doesn't include other assets, by the way, that we've put up. Davis Samuel had a 30% interest in rather a 20% interest in a public company, and that's since grown to $1 billion. Those assets are substantial, and we lost that, and that's another claim. That's a private claim that's gone in relation to that, and that's in the billions. And these are well documented, these claims, by the way. So I think that's what drives me to keep going, is to prove a point, never give up, and that's the motivation. And certainly never give up, because when you're in a position on an equal level playing field, you can take anybody and everybody on if that's the case, because you've got some reserves to play with. And that's why I cannot stress enough today's episode being about asset protection, and two simple documents that will give you the protection to at least enjoy your assets and or be in a position to fight to protect those assets from whatever sources that may come. And the irony is, of course, that the more money you end up parking, the more attraction you are to the wallies out there that either A, want to get it, or B, want to bring you down, which is the great, wonderful concept of the Australian tall poppy syndrome. So you'll cop that all the time, and it'll cop it even worse when suddenly people around you realise how that wealth has increased and where you got it from. So it's gone a lot longer than I'd hoped. A couple of those questions were fantastic, boys. Keep up the good work. The more attention we bring to your questions, the greater exposure I can to share some of the secrets of my background and story, which is my objective. Everything's transparent up front, everybody. Be safe, be zoo kind, and by word, it's ZuTime, and it's going to get better and better, let me tell you. Cheers, everybody.